protectors can be used also in dynasty trust, and I guess some people now are even using them in revocable living trust. It's a third party to whom the planner gives discretion over certain functions, including the power to amend the trust, the power to change the trust situs to another jurisdiction when duress events occur. It's called the duress clause. And the power to change the trustee or move trustee to a new situs or jurisdiction. And the power to veto trustee decisions, the power to veto distributions. The protector can be a relative, friend, or a third-party professional. As I've indicated, we have a hard time finding a protector because there is potential liability in the United States. Now, with foreign asset protection trusts, we don't have any problem at all because there are companies offshore that we deal with and have confidence in that will serve as the protector. And we like that because then the U.S. system, judicial system, has no jurisdiction over the protector. Many people still, they don't feel comfortable with that, and they might still have the relative or friend or CPA. In some instances, the lawyer acts as the protector. I have some reluctance to do that for the reasons that we discussed with my clients. I'd rather have, we're affiliated with an offshore company, and I would rather have the offshore company do it. We don't use our offshore company as a protector with domestic trust, however, because we don't want to have it registered to do business and have enough. If it's a protector with a domestic trust, then that might be enough to give the court's jurisdiction over that company. So what other attorneys have done, we have not done it, but we're considering it, is to form an LLC to be a protector for their domestic clients. So the gentleman from Idaho here, what's your name again? Steve, yeah. What do you, if you have a client that wants to have a U.S. protector, how do you handle that?
On an offshore?
Let him have the microphone here. Where is?
If I have a domestic asset protection trust,
yes,
and I want to get a protector I usually talk to the client about, first of all, how they feel about an institutional trustee, and if they're not open to that, then we'll usually look at their CPA. I don't offer up to be the protector. I have done it on a couple of occasions when nobody else can fulfill the responsibilities. And sometimes there might be an individual in the family that is suited, but that's my last choice.
Okay. If you do use a professional fiduciary, of course, that's another fee that's involved. You have the fee for being the trustee of the trust, and then you have another fee for being the professional. But it might be worth it to do that if the client's willing to pay that kind of money. My experience is that when push comes to shove, that the clients are going to use either a close friend, their CPA, or a member of the family. That's been my experience with the getting. Carol?
So Jeff, I'd love for you to elaborate more on your thoughts about creating an LLC to be the trust protector. Would that be in your office, or what are you thinking?
The problem with creating, here's the problem with creating an LLC. Some attorneys have done that, and the problem that I see is it's almost for certain that sooner or later that the protector is going to be held to be a fiduciary. If it's a fiduciary and you have then is the LLC going to be treated like a trust company? Has it met the requirements of being a trust company? And you've got all these other issues, and nobody knows what's going to happen because they haven't done it. It hasn't come up before. So that's the problem. I've wrestled with it because in effect, we've done that with offshore. Some attorneys that I know, it's easy to do it offshore because the jurisdictions aren't going to, there's no issue with a fiduciary jurisdiction offshore with a protector. And so there are LLCs that have been created by attorneys that do a lot of offshore stuff, and it works out perfect. But with the domestic, the problem is that going to be held to be a trust company? Is it going to be held to be a fiduciary? Is there going to be some liability? And so that's the issue. So I haven't done it. I know attorneys, though, who have done it, who do a lot of domestic asset protection trust. Steve?
Well, and I, in almost all instances, I have to say that my clients, they don't want to pay the extra money for the corporate fiduciary. And so it usually ends up mostly being a family friend or CPA.
I will say that with the high net worth individuals that do it offshore, they don't have any problem with paying in my experience, with paying the extra fee to have the protector. They want it, they want that. And in fact, they demand it. That's been my experience with offshore. But with offshore, the only people who go offshore are people who have substantial liquid assets. Yes?
Since you mentioned the word fee, I'm thinking in my head, we got trustee fees, filing fees, attorney fees. Now, what does something like this cost? If they did like a module sort of plan where you have the LLCs and the DAP and Nevada trustee, I mean, because I'm trying to get an idea as to what sort of market that I'm marketing this to.
I think, I'll talk about the modular system when I come to it later on in next hour after we have our break. But just to set up the LLC, the Domestic Asset Protection Trust, my experience is that the fee ranges from $5,000 to $15,000. That includes all the costs.
That's the legal cost.
Pardon?
That's the legal cost.
And that's the legal fees plus the trustee fees.
Okay. And then you got an LLC formation.
Then that adds on to the...
Okay. And then you got filing fees for the LLC, and then you have continuous trustee fees.
Yes.
Okay.
The trustee fees in Nevada are $1,500. In Delaware and Alaska, they're $5,000.